I'm Ben Meiselas from Legal AF, joined by our co-host, Karen Friedman Agnifilo. Want to talk about this order that was just recently issued by Fulton County Superior Court Judge Robert McBurney. Remember Judge McBurney? We used to talk about McBurney all the time. Where'd you go, McBurney? Judge Robert McBurney was the presiding judge over the Fulton County Special Purpose Grand Jury. Remember that? As well as he presided over proceedings related to the grand jury in Fulton County that ultimately voted to indict Donald Trump plus 18 other co-defendants in the sprawling RICO case that was just brought and being prosecuted by Fulton County District Attorney Fani Willis. But McBurney's duties were just related to those proceedings. He's not a judge of everything. So when the indictments were brought against these 19 defendants in the RICO case, the criminal case was assigned to a different judge who we've been talking a lot about here on Legal AF and the MeidasTouch Network, Judge Scott McAfee. Judge Scott McAfee was the one who's been signing all of the consent orders. He's the one who's been setting the arraignment dates. He's been moving the docket along expeditiously for all of the state court proceedings in the RICO case. So we haven't talked a lot about McBurney, but McBurney's name came up again because remember, the special purpose grand jury report that was prepared has not been released yet. Remember the special purpose grand jury report? Judge Robert McBurney had previously only unsealed portions of the special purpose grand jury report, which is basically the intro, the conclusion, and another section saying that witnesses who lied should be charged with making false statements and perjury. But it doesn't say who the people were. It doesn't show who the special purpose grand jury recommended be indicted, what the findings were. And so in this order, we have Robert McBurney basically saying that it would be his intention to make available, now that the indictment has been brought, the special purpose grand jury report, and make that available to the public. There may be some interesting findings there. Before tossing it over to you, Karen, I would just remind people that Fulton County District Attorney Fani Willis used a very unique procedure in Georgia. There's a criminal investigative grand jury called the special purpose grand jury that does not indict, that prepares a report. Then you have the grand jury, which can take the recommendations from the special purpose grand jury to then vote on an indictment, or they can take new witness testimony or a hybrid. They could look at the report by the special purpose grand jury and new witness testimony as well. We believe Fulton County District Attorney Fani Willis did the hybrid approach because we know witnesses testified before the grand jury, and we believe the report went before them as well. But Karen, what do you make of this? Do you think there's going to be some interesting findings here? We're definitely going to learn. I think what was going through the mind of the special purpose grand jury we've been talking about a lot on Legal AF a few months ago.
Yeah, I mean, look, it's sort of interesting because the special purpose grand jury wrote a report, right? And we don't know what is in that report and how closely it tracks what Fani Willis did or didn't do. For example, we don't know if they recommended against different people, more people, fewer people, or the same people, same as the facts and charges that it came up with. So it's going to be very interesting to see how closely these two things track. And what Judge McBurney said is on January 17th, he had a hearing of 2023. He had a hearing about whether or not this should be made public, because if you recall, the special purpose grand jury recommended that their report be made public. But the DA, Fani Willis, had requested that it remain confidential until she completes her investigation. It's in that context that she said, which will be imminent, right? My decision should be imminent. And that's when we were all saying, well, when's this going to happen? You know, you said this, in January, and where are we? What he now says, though, is because at the time that he agreed in February to keep it secret or not disclose the report, most of it, except the few portions that you suggested, that you talked about, until the DA completes her investigation. he said, since 19 people are indicted, there's no longer a due process concern about the February order that Judge McBurney issued, at least as to the 19 defendants who were indicted. He says, consequently, now I intend to release the remaining portions of the grand jury report unless someone thinks otherwise. So I'm going to give you until September 6, 2023 to file any objections. If not, then the remainder of the final report will be added to the docket, which means it'll be available for all of us to see. So what he's saying there is look, if someone hasn't been charged with a crime, most of the time, most courts would find that it's inappropriate to disclose, to tar them with the like kind of saying someone did something, but they're not charged, tar them with being a felon. And so that's why he would say there's a due process reason not to disclose the grand jury report as to at least those people who haven't been charged with a crime, because obviously an accusation can be damaging to people's jobs, to people's housing, to people's reputation in the community, to their family, to their lives. I mean, just to be accused of something. And so for that reason, the judge is saying there'd be a due process reason not to disclose people who aren't charged. But what he said is, now that they are charged, now that it's public, I see no reason that I can't release this. So, that's what kind of made my ears perk up or my eyes perk up when I was reading it was, I wonder if anyone else is in there, and will they say, okay, I'm not going to release as to those individuals because they were not charged, or, were there fewer people, or what evidence, what did, Fani Willis develop between the time that this report came out in January and the time it was released in August? I would guess, just again reading between the lines, that we're going to learn that the special purpose grand jury probably recommended against more than the 19. Fani Willis reached out to several of the other people, the people lower down, got some of them to cooperate. And they are the individuals named in the indictment as, cooperating witness or unindicted co-conspirator, or individual known to the grand jury. I can't remember how Fani Willis designated it, but, people who might have committed crimes or did commit crimes, but she flipped them. And some of these other low-level people, we might learn, she also approached but decided not to cooperate, right? And that's why they ended up being defendants. So we might learn the identity of some of the witnesses, some of the unindicted co-conspirators who are now cooperating. We might learn a lot when this report is published. And so that's, I think that's going to happen right around the time of arraignments, unless somebody files an objection, and then the judge is going to consider it. And then it might happen a week after that, is what I would say. But this report will very much give us almost like the map of and the book on Fani Willis's evidence and her indictment. And we're going to see that soon.
The first thing I'm going to do when I get a copy of that special purpose grand jury report is I'm going to read it. And then I'm going to compare it to the indictment right away. I'm going to look at the names. I'm going to say, who did the special purpose grand jury recommend to be indicted? Who did the grand jury indict? And then I'm going to try to fill in who are the unindicted co-conspirators that were providing significant cooperation to Fani Willis, such that, to your point, Karen, that they were not ultimately charged by the grand jury, but were recommended to be charged as part of a RICO racketeering criminal enterprise by the special purpose grand jury. And I also reflect on, just since where we are now with the indictment, it wasn't a long time ago that Donald Trump and his now fired or lawyer who resigned, Drew Findling, calls himself the billion-dollar lawyer in Georgia, they were filing all of these motions and losing every single one of them to try to disqualify Judge McBurney. They said McBurney's biased. Everyone's biased. Everything's unfair to Donald Trump. So they said McBurney's biased. You got to disqualify the district attorney, Fani Willis. You gotta, disqualify everybody from the district attorney's office. You got to disqualify the entire special purpose grand jury. The whole special purpose grand jury report needs to be destroyed and never see the light of day. Remember all of these motions that Donald Trump filed? He even brought one directly to the Georgia Supreme Court to try to block the special purpose grand jury report, and the Georgia Supreme Court ended up giving a very scathing ruling to Trump and his lawyers, saying procedurally, why are you just filing this with us? This isn't a court where you can just file documents with right away. That's not the way procedure works. But in any way, now that it's here, let me explain to you, Trump and Drew Findling, why you are wrong about everything here. And let me make a ruling on the merits about special purpose grand juries. And so the Supreme Court of Georgia did that. And so those were all the efforts of Donald Trump to try to block the special purpose grand jury report and its recommendations. And you still see some of these co-defendants playing games with the special purpose grand jury, right? You've got Jeff Clark, for example, the disgraced former DOJ official who wanted to become attorney general and then overthrow the results of the elections in the various states and send letters on official DOJ letterhead telling states to overthrow their election results. And Clark is like, this is a hybrid quasi-civil criminal procedure. It's like, no, it's not. A special purpose grand jury is a criminal investigative body. Just stop with the BS. Stop with the gaslighting. That's just not. All of the courts have said special purpose grand jury is a criminal investigative tool. Makes a report. That's what it does. The reports don't have to be followed by the grand jury. They can be followed by the grand jury. It's just a tool that prosecutors can use. But I'm excited to see this report because it's something we've been talking about a lot here on the MeidasTouch network. And so we'll be sharing that with all of you as soon as we get it. Karen Friedman, Agnifilo, thank you so much for joining us here again on the Legal AF Duets. Make sure you check out, everybody, patreon.com/MeidasTouch. The KFA origin story we did a special podcast for patrons. Go to patreon.com/MeidasTouch, MEIDASTOUCH. Learn the KFA origin story about Georgetown law, and that informed her career. And I went to Georgetown law as well. You'll hear somewhat of my origin story as well going to Georgetown. So check that out and go to MeidasTouch.com as well. Thank you, everybody, so much for watching this, and we'll be back for another duet soon.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.